As our update-a-palooza continues, let's jump on over to the West Coast and see what's going on there. I'm sure many of you remember Mr. Oregon, that amazing man-child from out west who believes that everyone should wear orange and smoke meth in Oregon, and that should be fine and legal, and takes 6 months to take a drug test so that he can see his child, and then pitches a fit because he can't see his child quicker. Everything's everybody else's fault, and the whole world hates him. Yeah, that guy. Well, he's been up to his antics again, but let's start from the beginning. If we look at this, poor Mrs. Oregon has been through the ringer. 69 hearings to date in this divorce case since it was filed April of 2018. How the hell has she not lost her shit? I have no idea. But I only have a couple of them, so you don't have to sit through that many hearings. Let's watch and be delighted by his antics. Yay.
And I think that does change the character as to my information today. Mr. Lawrence, did you have a chance to review the pleadings in this case?
No, Your Honor. I would like to address why in a few minutes, but I have not as of yet.
Okay. Ms. Gilbert was here 1 or 2 weeks ago with a social media entry by the father's current wife that raised suspicion of drug use. The father was also here, and after listening to the parties, I felt there was enough with the social media entry to reappoint Mr. Lawrence as guardian ad litem to investigate the situation, but I did not see sufficient evidence to change the parenting arrangement at this point. Anybody can post whatever they want on social media, and I didn't particularly want to rely on that. Since that time, Ms. Gilbert has filed with this court a statement under oath by the husband's current wife, indicating that there has been domestic abuse in the house, and specifically that it was committed in front of his son, which would be Ms. Gilbert and Mr. Gilbert's son. And as Mr. Lawrence knows, and I'll let Ms. Gilbert know, that if domestic violence is committed in front of a child, Washington State views that as if the child, as if the domestic violence was against the child themselves. So what we have today is specific statements that include the child, plus a statement under oath, which we didn't have last time we were here. Yeah. And I think that changes the character. And so Ms. Gilbert last time had asked that I suspend visitation with the father. As I said, I was unwilling to do that, but I am willing to do that today. Ms. Gilbert also asked that I sign an order for adequate cause. I am not willing to do that today until I hear from Mr. Lawrence and what his investigation shows. But I am willing at this point to suspend visitations going forward until we can hear back from Mr. Lawrence. Mr. Lawrence, go ahead.
Yeah, Your Honor, I contacted both Aaron and John after I received word that I had been reappointed in the matter. And I discovered that the court had ordered both parents to split the cost of my investigation 50-50. When I spoke to Erin, she indicated that she had hoped that John would pay for all of it. I assume because it was his actions that caused this matter to go forward. And when I spoke to John, he indicated that he had paid me enough money from my 2 previous reports that I prepared for the court and didn't want to pay any more money for this investigation. So I'm in a situation where there's no guarantee I'm going to get paid to do this. And so I wanted to bring it to the court's attention this morning.
All right, thank you. All right, I've signed an order that requires that Mr. Gilbert not disturb Ms. Gilbert or the child, that he has to stay away from them, and he's not to go within 500 feet of their home, vehicle, workplace, school, or daycare or school of the child. Okay. So as to fees, Ms. Gilbert, I'm concerned, not in this case, but in all cases, that if one party pays all of the fees, then the other party can take the position, well, they paid the fees, and so the report slanted in their direction, or, and it just makes better sense for the parties to share the fees. So I'm going to require that you pay half of that, unless you're not able to pay because of your income level, and then you can petition the court by submitting an income statement, and potentially the county can pay at that point.
Okay.
Now, as to John Gilbert, and he's not here, I can enter a judgment against him. I guess that would be the next step. That probably is not very satisfactory to you, Mr. Lawrence. What would you recommend we do with Mr. Lawrence?
Well, Your Honor, the court has imposed significant leverage at this point by stopping the visits between Max and his father. And quite frankly, under normal circumstances, I don't start my investigation until the fee has been paid, and I can talk to him about that. And so if he wants to reinstate his visits, he's going to have to at least work with me on this thing.
I think you should express that to him. I'm not going to reinstate until I get a report from you.
Yeah. And so anyway, I will make contact with him, and if that becomes a problem again, then I'll note it back up.
Okay, Ms. Gilbert, I see 2 restraining orders. Let me see what else is here. Okay, so I've signed one of them. I'm not going to sign 2 of them, and then also your order for adequate cause is here, and I'm not going to sign that at this time. Any questions, Ms. Gilbert, at this point?
I don't think so. Probably
Okay.
as soon as we hang up, but no.
Okay. I should probably set a review hearing. Let's set a time to come back on February 1. That'll be at 9 o'clock. I just want to check in with Mr. Lawrence as to the status of the investigation, and then any other issues that are occurring between the parties. I don't expect your report to be completed by that time, Mr. Lawrence. I just want to check in. All right, last time we were here, Ms. Gilbert had filed with this court a declaration by, I believe, Mr. Gilbert's current wife that raised issues about domestic violence being incurred or
Hey, why can't I hear him speaking?
just a minute here, occurring in front of the son. As a result of that, I believe I suspended visitation and reappointed Mr. Lawrence to review this matter. Mr. Lawrence indicated he reached out to Mr. Gilbert. Mr. Gilbert was unwilling to pay Mr. Lawrence's fee. I put this over to try to address some of those issues. So maybe let me hear from Mr. Lawrence first if anything's happened since last time we were here, and then I'll let Mr. Gilbert address the court. Go ahead, Mr. Lawrence.
Your Honor, I have made contact with both Mr. Gilbert and Ms. Wilbanks. I have received payment from both of them, full payment. And I went down, I believe it was last Saturday, to Ms. Gilbert's residence and met with her and their son, Max, and was able to interview them. I spoke with Mr. Gilbert this last Monday over Zoom. And so I have had compliance in that they have met with me. They have provided Max access so I can interview him. And they've also both paid their bill in full. So we're good at this point.
Okay. All right. Thank you, Mr. Gilbert. Thank you for that cooperation. Mr. Gilbert, anything you'd like to say at this point?
I'm not going to get a fair thing here in front of Keith. I have stated my opinion before. His reports, I think, are incomplete. He contradicts himself. I think he's incompetent. And if the courts want this to go any farther, I would like a fair chance. I would like a different guardian ad litem involved in this, because our interview was maybe 10 minutes on the phone, and that was it. Over the years when we did this, I've invited him out to the house and stuff. He refuses. He's went to her house several times. He's refused to come out to my house. He does everything on Zoom, and it's such a short, fast, incomplete meeting with him that, looking out for the best interest of the kids, I would like another guardian ad litem if the court wants this to go any farther.
Right. Thank you. Ms. Gilbert, any comment?
I mean, well, just Keith has not been to my house several times, but I mean, I think it's fine. I'm not sure that Keith is done with his, or what exactly he's doing. But anyways, no, I'm fine with Keith.
Mr. Lawrence, I guess I should give you an opportunity to respond to Mr. Gilbert's request that you be replaced.
Yeah, thank you, Your Honor. When I met with Mr. Gilbert on Monday, I wanted to discuss the issues that are at hand here. There's allegations of domestic violence and drug use by Mr. Gilbert, and that use was presented by Brenda, his current wife, in a post that Ms. Wilbanks picked up on and filed her paperwork to start this whole process. When I spoke with Mr. Gilbert, he was reluctant to discuss any domestic violence issues. He indicated that has all been resolved. and that Brenda has dropped her protection order request. That may be true, Your Honor. However, the situation that led to it certainly could still exist. Also, he accused me of listening only to Aaron's side of things, and I tried to explain to him that that was not what caused this whole process to begin. It was his wife's posting of the drug use and the domestic violence that caused this proceeding to get going. He then wanted to know, well, who was going to pay him for a week's vacation that he had to take time off of work to deal with this. And so at that point, I felt that no matter what we were going to be discussing, he wasn't willing to discuss it. He was being argumentative and trying to put all of the blame onto Aaron, who had nothing to do with starting this thing, other than being concerned about the post that John's wife put forward. So I felt it was non-productive. We would just be in an arguing situation. And so I terminated the interview at about 15 minutes.
All right.
Can I say something, Your Honor? Did Mr.
Yes,
Lawrence,
briefly.
did
Mr.
Mr.
Gilbert, go
Lawrence
ahead.
did Mr. Lawrence get the police report from the night that they're talking about?
I have a few police reports that were provided by Aaron, and I haven't had a chance to go through them yet.
So you got a report done and you haven't even looked at the police report. That's what I mean by incomplete and incompetent.
I don't think there's a report done yet. I don't think he's reached a final report.
No, Your Honor.
All right,
Well,
I'm going to replace Mr. Lawrence in this case. Do you have any recommendations at this point, Mr. Lawrence?
My recommendation, Your Honor, is to continue status quo at this point. The court wanted me to provide a full report on this before making any changes on the visitation. I would recommend that we continue with that line of reasoning and give me a chance to totally sort through this thing.
All right. Mr. Gilbert, what would you like to see happen?
if the court wants to continue this, that's fine. I'm willing to do what the court wants. All I ask is it to be fair. And Mr. Lawrence, knowing how I feel about him and how I felt about his last reports over the last 4 years, I'm not going to get a fair chance. So I think if the court is really looking out for the protection of Max Gilbert, the 11-year-old boy in this, they would assign a different guardian ad litem to come out and actually do a complete report, because I'm not going to get one from Mr. Lawrence.
All right. Well, the allegations that
I'm willing to take UAs and clear this up. I mean, you want me to do weeklies, whatever, I will go down and do it.
okay. The allegations deal with domestic violence and potential drug abuse. So the court needs some objective information regarding that. Mr. Gilbert, what I'd like you to do is what's called a 12-panel hair follicle test. You can do that at Columbia Wellness, or there may be another place to do it.
Whose cost, Your Honor?
At your cost, sir. And also, I'd like you to have a substance abuse evaluation. And that, I believe that can also be done at Columbia Wellness. It'll probably take about 3 weeks to get both of those completed. So I'm going to continue the status quo for 3 weeks. That goes to the 22nd of February.
So, Your Honor, my kid is being suffered here. He don't get to spend time with me and stuff over this. I mean, I'm found guilty on something that I haven't even been to court or anything on. And my kid is suffering on this. And the police reports, if you get the police reports from when the sheriff was out here at the house and stuff, it clearly shows I did not have a problem. I took the breathalyzer. I did everything out here. And if Mr. Lawrence asked my kid if he seen the cops out here, my kid was nowhere even here. He was not here at the house at the time of the incident or anything else.
However, the declaration from Brenda that was filed with the court and was attested to under penalty of perjury indicates that domestic violence occurred in the presence of your son.
Oh, it was the sheriffs were here and stuff, and we have a parent plan in place, and we can look at the dates that the police reports were done on, and it will clearly show that the parent Max was not with me on those weekends. He was with his mom. The parent plan would clearly show the dates and everything else. That's all I'm asking is the court to look at that, look at the date the police reports were filed. Max Gilbert was with his mom, not even with me. So what was put in that report is incorrect.
Okay, so let me invite you to do your own declaration, attach the police reports, and make that argument because that information is not in the file at this point. Mr. Gilbert, let me tell you that if the hair follicle test is negative, as you're telling me it will be, if the substance abuse evaluation comes back okay, I want to see you spend time with your son, and we'll work towards that. But at this point, given the allegations, I need some objective evidence to make sure we can take that step.
You can't make up a week's paid vacation that I saved up all year long over Christmas and stuff. You can't make up these weekends I'm missing. I have to work. I'm behind on my payments right now on everything else. And I'm going through all this bull crap. And like I said, if Keith did his report correctly, he would have got the dates. He would have seen the police reports, and he could have verified that Max Gilbert was not even with me. It should have all been cleared up over this. And that's why I'm asking for a different guardian ad litem to be assigned to this case. Because dates, clearly, there's a parent plan that is in place, and it would clearly show my kid was nowhere around.
Okay, sir, I want the objective test done before I make the next decision in this case. Okay.
Your Honor, if I might.
Yes, please.
On the substance abuse evaluation, I would suggest that the court allow input from Aaron Wilbanks. Usually when we have a substance abuse evaluation, and if there is an input from other parties, they can often not get a full picture of the issue.
Okay, I will I'll agree to that. And so wherever the evaluation is, Ms. Gilbert will need to be informed so that she can talk with them.
Okay.
Can we ask for this to go both ways, Your Honor?
Say that one more time.
Can I ask for this to go both ways? Both of us? Aaron Gilbert has not held a job in over a year and a half. She cannot stay working at one place, so I guarantee you she's not going to pass one. So I have to find it on Facebook or something? Do I have to get something posted out there? Ask her how many jobs she's had in the last year and a half and how many jobs she's lost in the last year.
Can I object to any of this? He literally is just rambling with zero. He has not, like you said, Judge, presented any paperwork in any sort. He is just rambling.
I will prevent the paperwork.
All right, we're going to bring this to a conclusion. I've made my ruling. I need to see the hair follicle test and a substance abuse evaluation. There's no allegations against Ms. Gilbert at this time.
There will be.
Order that she do anything. And we'll be back here on the 22nd of February at 9 o'clock. And I think Mr. Lawrence is the GAL in that case. I know Mr. Gilbert is in the booth at the courthouse and Aaron Gilbert's here. Let me get to my notes. Last time we were here, I required a 12-panel hair follicle test by Mr. Gilbert and a substance abuse evaluation. I didn't see anything in the file. Mr. Lawrence, are you aware of if those have been completed?
I have not seen anything, Your Honor, and I checked Odyssey on Friday afternoon and didn't see anything either.
Mr. Gilbert, have you accomplished?
That was on the internet. And it clearly states it was Portland, Oregon. Measure 110's effect February 1st of 2021, which decriminalized possession of cocaine, heroin, methamphetamine, oxy. So I don't understand what a hair follicle sample is going to prove anyways.
So we're here because your current wife filed a declaration in a protection order case alleging concerns about drug use, about domestic violence, and domestic violence involving your son. That's why visitation is suspended at this time. And we're not going to be able to move forward until you get both the substance abuse evaluation and the hair follicle. And if it shows that nothing's going on now, I will be happy to reinstitute visitation, but I need objective evidence that that's the case.
I can't afford it, Your Honor. And by what she was stating, it was stated in the state of Oregon. If you look at where she stated it, it was the state of Oregon, which measure 110's in effect February 1st of 2021. So it wouldn't matter if I did it in the state of Oregon.
All right. Well, I'm sure you're aware of the declaration that I received, which has been recent. What
are you looking at?
Mr. Lawrence, have you had any contact with the parties since our last meeting?
No, I have not, Your Honor. I was awaiting the results of the hair follicle and the substance abuse evaluation. I did have an email communication with Mr. Gilbert's wife, wanting to know how she could get these evaluations and hair follicle exams obtained. And I gave her some information on that, and that was my last communication.
All right.
I can't afford it, Your Honor. With child support, everything else, missing work, I can't afford to do it. So what am I being sentenced for?
Ms. Gilbert, any comment?
I mean, I'm sure he can afford it. So I don't know. I don't know what to do.
Sir, I'm still going to require the test and the evaluation. And I'm going to put this over a month, and hopefully you're going to be able to find the funds in that time.
So if not, how long is my visitation suspended for? What's my charges and what's
It's not going to start. It's not going to start until you do these two things, which is do a substance abuse evaluation and a 12-panel hair follicle test.
So I'll miss some work and everything else, and it wouldn't matter if it comes back positive or negative if it states that I was in the state of Oregon. How are you going to know what state I was in if I was doing it?
You're not being charged with anything.
I'm not being charged with anything. Yes, I am. I've lost the visitation of my kid. I've had to pay the guard, the license.
Charged you, dumbass.
Market on my back.
All right. So my ruling stands. You need to complete those two, the substance abuse evaluation, the 12-panel hair follicle test, before we consider additional visitation. And I'm going to put this over to March 22nd at 9 o'clock.
So I'm not being charged with nothing?
No, not here. It just, I'm suspending your visitation because of the concerns that were raised in the declaration that was filed in the protection order case.
In the state of Oregon.
That declaration was filed in a Washington case.
But it clearly states on Facebook and everything else that it was in use. She put drug use in the state of Oregon.
Domestic violence in
So
the
I'm
state of
not gonna argue
Washington.
with you about that. So I made my ruling. Thank you.
Thank you.
We'll see you back here on March 22nd. Mr. Gilbert's here in the courthouse. Mr. Lawrence is here and
I'm
Ms.
here.
Gilbert is in her car. Last time we were here, I reiterated the requirement for the 12-panel hair follicle test and a substance abuse evaluation. Have either of those been done, Mr. Gilbert?
No, I said I couldn't afford it.
All right. Mr. Lawrence, have you been able to look into this case?
All I've done, Your Honor, is my initial investigation in this, and I checked yesterday to see if any documents had been filed, and there were none. I guess my suggestion at this point is that we simply leave status quo in place until Mr. Gilbert decides to comply with the court's orders, and then he can petition to have it reviewed.
That was one of my thoughts. Ms. Gilbert, when these issues first came up, you asked the court for an order of adequate cause so you could potentially make a permanent change in the parenting plan. Would you still want to do that? Or there's also Mr. Lawrence's thought that we just leave this until Mr. Gilbert gets the test and does the evaluation?
Yeah, I mean, I guess if we could leave it and give him more time, I guess, yeah, I'm not sure what the best thing is, but if he did do it, then that would be best. Sorry. So yeah, I don't know if we can leave it for a while and see if he does something before making it permanent.
Ms. Gilbert, what would you think of having at least telephone contact between Mr. Gilbert and Max at this point?
Oh yeah, I mean, I believe they do. Yes.
They do already?
Yeah. I mean, I believe so.
Okay.
How long is Max gonna be punished and kept away from his grandparents and stuff? Over hearsay on the internet.
He never sees his grandparents that side anyway, but
Mr. Gilbert, I
Else with
just want to remind you, it's more than hearsay. We have a sworn statement by your current wife that has raised these issues. So,
police reports say different.
okay. Mr. Gilbert, it sounds, are you in telephone contact with Max at this point?
Yes, I've talked to him a few times. Yeah.
Okay. Sir, I'm going to allow the telephone contact to continue.
What about his games and stuff?
Well, at this point, I'm not going to allow you to see Max until you get the hair follicle test and get the substance abuse evaluation. And I'm going to take Mr. Lawrence's suggestion, and I'm not going to set another review hearing. When those two things are completed and I can see the result, then you can put this back on the calendar for the court so I can look at it and I can determine what a safe visitation plan will be. But until I get those tests, I can't determine that.
So when they come up all negative, how can you take away all the priceless time I've missed out and everything else?
Well, that might be something I take into consideration, but I need to see negative tests before I can even consider that.
You'll never be able to make up priceless time I've missed with him.
Well, sir, I've had this order in effect since February 2nd.
I can bring my bank statements down and showing you I ain't got no money. Work right now is really slow.
All right, so what we're going to do today then is I'm not making any other decisions. I'm leaving the orders for the tests and the evaluation in place. And when they're completed, Mr. Gilbert can put this back on the trial calendar or on the court's calendar. Okay,
Thank you, Your Honor.
that's it
Thank
for
you.
today. Thank you. All right. Mr. Lawrence, have you had a chance to meet with the parties recently?
Yes, Your Honor. On Friday, April the 28th, I was at the clerk's office and I observed Mr. Gilbert there filing documents. And I got a chance to ask him about the status of his substance abuse evaluation. And what I understood was that that was one of the documents that he was filing with the court. So I looked in Odyssey yesterday to see what the evaluation said. And it turns out that all it was just a hair follicle exam that was administered on April the 18th. And it was a 5-panel test that came back negative for the drugs tested. So we still don't have our substance abuse evaluation.
All right, thank you. Mr. Gilbert, any response to that?
I do not have a drug problem. I passed the test. Throughout this whole thing, I've been famous at work. It was all over the internet. I had to go talk to HR. They've already gave me a drug test. I've already took your hair follicle test. There is nothing. I submitted the police report. The sheriffs that showed up out at the house that night said there's allegations that did not make sense that she made against me. All of this stuff. I have did everything. I am so tired of fighting for my rights here and stuff and being forced to go prove this, go prove this, go prove this. You've got a drug test. You've got everything. I have lost the most important thing to me, my visitation rights with my kid. I never took my kid up to the house when me and Brenda weren't getting along. I would not put my kid in harm's way, but I am the only one that lost visitation rights to my kid. I do not understand. You've got a drug test. I've been drug tested through work. No company's letting you work for them when it's all over the internet and stuff. I've continuously missed work and come into court nonstop. There was never any charges filed. There was nothing.
Mr. Gilbert, I did see the negative test, and I'm glad that that was negative. Let me ask you a couple questions. If I were to order initially a supervised visit between you and your son, is there somebody that you would feel could serve in that capacity?
Why do you want to humiliate me that bad?
I don't want to humiliate you. I want to make sure your son remains safe.
My son has got no violence on my record, no nothing. We've got kids at the house all the time. I've never did anything wrong. There is nothing in my background. I do not understand how all this is coming about. I mean, to have to stoop to visitation rights. I'm a father. If you look back for the last 5 years, I've did nothing but fight for my rights to visit my kid. I was told through the courts and everything else, if I moved to Toutle, even in the guardian life report, I would get more time with my kids. I stated to the court, as soon as I moved to Toutle, she would move. I moved to Toutle 2 months later. She sold the house that meant so much to her and everything else and stuff and moved out of Toutle. I lost every other weekend. And now on nothing, visitation rights. I pay my child support. I do my thing. My kid is the world to me. I would like to know where this is coming from.
It's coming from a sworn statement that was filed with the police department by your current wife.
Did you read?
I need to make sure that your son is safe. And initially, I'd like to see supervised visits.
Will you please read the police report I turned in?
I did read it.
Your Honor, I'm sorry. This is Gilbert, and I'm just jumping on. I was never notified about this court date.
Let me take a look here, see if I had. There was one set for last week, but the judges changed the schedule. So there was a document sent out changing the hearing date till today. So I apologize you didn't get notice, but you're here now.
Oh, I mean, I didn't get notice about it last week either, so I don't know anything about what's going on.
Well, we weren't here last week. Let me start from the beginning. Mr. Gilbert has turned in a hair follicle test that is negative. Mr. Lawrence has indicated that he hasn't done the substance abuse evaluation that we had discussed. I turned to Mr. Gilbert and asked if there was somebody who could preside over supervised visits for a few weeks. And he had a very strong negative reaction to that. So since Ms. Gilbert, you're here now, I will let you respond if you'd like.
I mean, I just feel completely unprepared. I didn't know anything about any of this. Does he not have to serve me? But yeah, I mean, I honestly just feel completely unprepared. I would definitely still want him to do the evaluation. Supervised visitation would be good. I guess I don't know what the proper protocol is.
You seriously think I need supervised visitation, right? You don't think I love my kid more than anything?
Well, apparently not more than
Let
drugs,
me
but
let you know, just a minute. Your attitude today is causing me more concern than anything. Okay.
thank you. That's is exactly
I
yes.
am wanting to protect your son, and you're yelling at the judge, and that is completely inappropriate and makes me more concerned. All right. I'm trying to figure out a way for you to see your son in a way that I know everybody's going to be safe. Now, you can work with me on that, or you can continue to yell at me. I don't care which, but I'll tell you, if you yell at me, we're not going to get anywhere. Now, want to work with me on that?
Yes, sorry, I was not yelling at you. This is the most hurtful thing I've ever been through in my life. Anybody you pick for supervised visitation rights, go right ahead.
All right. I understand we don't have an SUD assessment. We do have a hair follicle test that's completely negative. It gives me some relief that Mr. Gilbert probably does not have a drug issue. But in the at this point, I think the initial visits need to be supervised and see how they go. Ms. Gilbert, is there somebody you would feel comfortable with supervising those visits?
I mean, just the problem is that, you know, we just don't get along so great, and our families don't. I can't even think of anybody who would be a, you know, I can't think of the right word, but just a third party that would have no affiliation. Yeah.
How about Jeff Erskine?
The thing is, I mean, I haven't even had any time to think about it. I don't even know if supervised. I mean, my rationale is that John is angry, and so I do not believe he would hurt Max. I just know that John would hurt me, and so I don't know. I know that anybody on his side would lie. I don't know. This is just a mess.
Excuse me, Your Honor, but she just said I would never hurt my kid.
But you would hurt me, and hurting me or hurting, if your main goal is hurting me and you have to hurt Max to accomplish that, I believe you would not just hurt Max because you don't like him. You would hurt him to get back at me.
All right, let me go back to Mr. Lawrence. Any thoughts on this, Mr. Lawrence?
Well, Your Honor, in my dealings with this family, one of the things that I've noticed is that Brenda, John's current wife, was always a staunch supporter of his. For her to go out on the end of the limb like she did by posting what had happened that day was a real departure from that relationship dynamic. And it appeared that she was very afraid of his behavior during that time. Mr. Gilbert has not even admitted that he has done anything wrong. Just because the police didn't charge him doesn't excuse the behavior. And so at this point, I see him minimizing all over the place, and which gives me great concern. And this resistance to getting the substance abuse evaluation, knowing full well that it's going to interfere with his visitation with his son, it appears that not getting the evaluation is more important to him. And so I have some real concerns. I know that both the families are really have had issues over the years. If we're talking supervised visits, I think the only option would be professionally supervised visits through reconnecting families.
All right. I want Mr. Gilbert to have a way to see his son.
Thank you.
I understand he hasn't done the substance abuse evaluation. That order will remain in place and needs to be done. It sounds like that really the only way we can do this is to order supervised visits through an organization called Reconnecting Families. And Mr. Gilbert will need to contact them, set up a time for the visit. Ms. Gilbert, you'll need to cooperate with bringing your son over for those visits.
When is that, Your Honor? What place do I have to contact?
You'll need to call an organization called Reconnecting Families. Tell them you're setting up supervised visits and work out a time that will work for both you and Ms. Gilbert. Ms. Gilbert will probably bring your son over a few minutes before you get there so she can leave, and then you'll show up, you'll have your supervised visit. Mr. Gilbert will need to pay for those visits. I'm going to allow one a week for 4 to 6 hours. Hopefully we can get that done, and let's come back here in a month and see how that went. So we'll be back here on June 7th.
Your Honor, can I please ask what else will there be so I can get back to a normal life, feeling like a father again?
We'll see how the supervised visits go, and then we'll make those decisions.
Can I ask Keith one thing?
Why don't you call him afterward and talk to him? Okay. All right, so the evaluation order remains. You can have visitations that are supervised through reconnecting families, 1 visit a week for 4 to 6 hours, and we'll be back here on June 7th.
Can I just revisit the I was not served anything for this? Is that not a problem?
I'm sorry that happened. That was through the court. Do you want to come back next week and discuss this again? I'm not sure it's my decision's gonna change. But if you feel you need.
I guess not necessarily, but even, the reconnecting families and all of this is just so weird and a lot for Max to go through. And yeah, I just wish I would have had more time to think about it, but I guess this is what we're gonna do.
Let me invite you to call Mr. Lawrence, and I think he can answer all of your questions about that. Mr. Lawrence, why don't I start with you? If you can give me an update on what's going on, or if there isn't one, I'll ask the parties. And you're muted right now, Mr. Lawrence.
Can you hear me now?
I can.
I met with Mr. Gilbert probably about 2 weeks ago. He had some documents for me, none of which were the drug and alcohol evaluation that was ordered by the court. I checked with the Odyssey file yesterday to find out whether or not he might have submitted the drug and alcohol evaluation, and I found that none has been filed. I saw his declaration in there where and I'm trying to get this correct. Brenda had alleged that he gets up at 1:30 in the morning to drive to Portland to buy meth. And Mr. Gilbert was indicating that he couldn't understand why the Washington courts would be concerned about that because it's legal in the state of Oregon. So he was essentially admitting to using meth. He also indicated that, or provided a copy of the sheriff's report from the incident involving the domestic violence incident involving John and Brenda Gilbert. And at the investigation level, they couldn't determine whether or not domestic violence had occurred or not. It was alleged that Mr. Gilbert threw her down, but the officers found her laying on the hearth of the fireplace, and she had apparently injured her head, but had refused to undergo medical treatment. The officers tried to diffuse the situation by requesting that she go live with her, or at least spend the night with her parents, who were only a few doors down, and she refused. And the officer interviewed her father, who indicated that she has bipolar disorder and schizophrenia, and that she's not medicated currently. And when she drinks, she becomes out of control. So the situation is not getting any better, Your Honor. We have an untreated bipolar schizophrenic who may be drinking and getting out of control, beating Mr. Gilbert's truck with a piece of wood. He provided pictures of some of the damages that she had created. But also, he freely admits that he uses meth, and can understand why the court here would be concerned about that, because it's legal in the state of Oregon. And it also indicates a level of urgency and motivation that somebody who works as a logger and has to be to work early in the morning would get up at 1:30 to drive all the way to Portland to buy his drugs and then work all day. So I'm again at this place where we have been talking about trying to get Mr. Gilbert to undergo a substance abuse evaluation. He's alleging he doesn't have the funds to do it, but yet he has the funds to buy meth. And so I think the court needs to hold firm on this, that the status quo will remain until he gets his drug and alcohol evaluation completed.
All right, thank you. Ms. Gilbert, I'll let you comment next.
Yeah, well, I basically had the same feelings as Keith. I still would like the drug evaluation. He was ordered to do a 12-panel and only did a 5-panel drug test. And I was also wondering about reoccurring tests, if that was possible. But other than that, I agree with Keith.
All right. Have there been any supervised visits since we were last together?
There was one last weekend.
Okay.
Can I say something, Your Honor?
Mr. Gilbert, your turn.
First off, I'd like to apologize for the way I acted here, but I did the drug and alcohol evaluation. I don't understand. I got the receipt right here. If you can see it or not, it was done.
When did you do that?
It was done last Friday. The tribal center couldn't get me in. They were weeks out. I went down there. I did it down in Chehalis, but I did it last week on Friday. And they should have Keith Lawrence's email address. They had Aaron's email address. They had everything. And I mean, I would first off like to state, I work for a very big company. We have to type in, I can get notes for that. We have to type in our mileage on our pickups every day. From where I live, there's no way I'm going to Portland in the morning. My company has UA'd me after this came out, everything else. The company thinks it was a joke that it was even put out there. I do not have a drug problem. I will do your UAs, whatever, and stuff. The mileage, if I have to get a note from the company I work for, the mileage does not work out. We have tablets in our things. It's got GPS tracking. I was not in Portland. I do not have a meth problem. They do not, with the price of fuel and everything else, they do not allow us to drive our crew buses to Portland to go do personal things. I'm working in Milton Road. I live in Toutle. The miles and stuff on my pickup do not add up. If I have to go to my work and get notes and stuff like that, I will go down to the office. I will turn in notes because none of that makes sense at all.
All right, so Mr. Gilbert, what I'm looking for is objective evidence that you don't have a drug issue. And apparently you did a drug and alcohol evaluation Friday, but we don't have the results yet. Apparently you do UAs for your job, is that right?
Yes, I work for a very big logging company here.
What's the most recent UA you did for your job?
Right when this all went around, it was around January, and then February, the Super Bowl weekend, I did one then and stuff. I will go right down right now and go do one and bring it back to the courthouse. I mean, if
I was hoping there would be one a little more recent than that, but it may be helpful to see a pattern of clean UAs from your employer. So all I'm saying is I need objective evidence. Today we don't have it, although you've done apparently what the court has requested. So do you think you can get the UAs filed with the clerk and this evaluation filed with the clerk by the end of this week.
Yeah, I'll go do a UA right now and get it filed in here.
Okay. Well, then, why don't we come back a week from now, look at that documentation, and then we'll make some decisions on how we proceed.
Can I just say one thing?
Sure.
When this drug evaluation thing came about, Keith asked if I would be able to talk to the person doing the drug evaluation. And so that was a part of it. And I did not talk to that person. So I don't know if now that ship has sailed or if that's possible.
Well, let's do you know the company that you did the evaluation with?
No, I got their address. I would have to find it and stuff, but I can get the number and stuff like that. I gave them Keith's email address and stuff like that. I mean, I took pictures of a bunch of the questions on my phone. I could hold that up if you want to see that or whatever. I got the receipt, everything right here.
Isn't their name on the receipt?
No, yeah, New Direction Counseling, P.O. Box 59, Chehalis, Washington.
All right, New Direction Counseling. And Ms. Gilbert, I'll invite you to give them a call today if you'd like.
Yes. Okay. Thank you.
All right.
So,
All right. If you can get that stuff filed by Friday, then let's come back next Monday and take a look at it.
what do you want me to do? Just call these guys and have them get a hold of them, do a UA. I can run do that and turn it all in now.
Well, if you want to do a UA, that's great. But I need to see the results of your drug and alcohol evaluation that you did in Chehalis. And I'd like to see 2 or 3 of the UAs that you've done at your employment.
Okay.
So if you can go there, I'm sure they'll release that to you, and then just file it with the clerk's office, what we call under seal, which means that it's private so that only I can see it and not the rest of the public. Okay.
Okay.
And you should provide copies of all that to Mr. Lawrence to review also.
Okay.
And Miss Gilbert, please.
I don't think
And Ms. Gilbert. And before we leave, how did the supervised visit go?
it went great. I want more, but she didn't classify that she has 3 jobs. So trying to get time. I open 7 days a week, but in a month, I've only got 1 visit. I wish to try a little harder, and I would like to get her work schedule, because if she works 3 jobs and she will never disclose when she works, it's always a no-go, no-go, no-go. And I would love to see my work.
All right, let's not address that today. I want to address the visitation schedule next week once I see the results of these tests. Okay.
Okay.
I don't want to address it now because I would just end up readdressing it next week, and I don't think we need to do it twice. Okay.
So, again,
Mr. Lawrence, anything before we leave?
Yes, one matter of clarification, Your Honor. You indicated next week, which I assumed was Wednesday's docket, and then you mentioned Monday. Do you mean Monday or do you mean Wednesday for the hearing?
If I said Monday, I think that was a mistake.
Okay.
So it's June 14th.
Okay.
9 o'clock, we'll be back.
Thank you.
All right. Thank you, everyone. We'll see you then.
Thank you.
I believe they're both here.
Yes.
I need to let a couple people in here. Mr. Gilbert, I gave you a week to file documents demonstrating your clean UAs and your evaluations. I received nothing.
you should have received them. I dropped them off here.
When?
They were dropped off yesterday. Everything was dropped off here.
Just hang on a minute. I'm going to check another database to see if it's in process. If you drop something off the day before the hearing, it doesn't get scanned and put into the system. but this other database will tell me whether it actually is filed. So just give me a moment, okay?
All right.
If only done to you, you can inform the court.
Ms. Gilbert, did you receive anything from Mr. Gilbert?
No.
Did you provide it to Ms. Gilbert?
I didn't have time to get it up there. No.
All right, I just received a bench copy in this case. All right, just hang on. All right, I received test results. One dated May 2nd, 2019, that was negative. The next one dated June 7th, 2023. That shows negative across the board. And the other one, April 18th, 2023, also shows negative across the board. All right. Ms. Gilbert, I know you haven't had a chance to see those test results. Any comment you'd like to say for today?
I mean, just that he said that he had clean ones from January and February that he could file, but obviously did not. And I did try to call the, drug evaluation place, and they said that there was no release. Well, they didn't believe there was a release, so they couldn't talk to me about it. So I haven't got any of that information.
Mr. Lawrence, any comment?
Yes, Your Honor. Your Honor had ordered that it undergo a substance abuse evaluation with the input from Ms. Wilbanks. We keep coming back and coming back and coming back. At the last hearing, Mr. Gilbert indicated that he had the results of an evaluation and that he would file it that day. And he did not. I'm frustrated that he just won't provide the substance abuse evaluation. By his own admission in his declaration that he used meth in Oregon and couldn't understand why the state of Washington could be concerned about it being legal in Oregon. So there is definitely a problem here, and an evaluation without the input from Ms. Wilbanks is going to be worthless. Self-reporting does not work in drug and alcohol situations. My suggestion to the court is that we simply stop having these hearings until Mr. Gilbert obtains that evaluation with Ms. Wilbanks' input and files it with the court, and then he reschedules the hearing. Otherwise, we don't proceed.
All right, thank you. Mr. Gilbert, any response?
Yeah, I talked to the place Monday. They've got Keith Lawrence's email address. They've got her email address and everything there. Everything should have been released to their emails.
Who did you talk to on Monday?
I don't know the lady, the evaluation place that I did down in Chehalis. I ain't got my.
You don't know the name of the evaluation place?
Not right offhand. It was on the receipt. I told you the name of it last time we were in court.
Have your email
But
address.
it all done, everything else and stuff. And with this going on, when I was ordered to do the hair follicle test, Keith came back and said that if anything showed up besides pot, because pot's legal in the state of Washington, I claimed everything's legal in the state of Oregon. I never, ever claimed I've ever did meth. I do not do meth. You've got the UAs there. If this is going to continue on, I know he's going to get mad about this. I like to subpoena Merrill Lynn. He's our HR guy. representative. He can come in here. He can explain to you how the fuel cards, they track the mileage, they track the fuel every day when we get fuel and stuff. We don't fill out paper tickets anymore. All of the tickets and stuff that we fill out, they have GPS location on it, coordination, everything else. It gives dates, times, and stuff. There's no way I'm joyriding a crew bus in Portland. There's no way that I came in here and did that. I mean, right now, I'm the most popular guy in the company. Everybody watches these Zoom things and stuff like that. And never once have I said I did it. I do not do meth. It is legal in the state of Oregon, just like prostitution's legal in Nevada. I do not do it. And I mean, what happened innocent until proven guilty, or slander, defamation of character? Because if you go through all these court hearings and stuff, never once did I ever admit to doing meth. I do not do it. I don't even have pot in my system, and it's legal in the state of Washington. I don't do drugs. So if this continues on, can we subpoena Merrill or our HR guy? Like I said, I got a huge target painted on my back through all this stuff. They're questioning how much work I've been missing coming in here all the time.
Any response, Ms. Gilbert, before I make a decision?
I mean, just that he's had, 6-7 months now to produce any sort of anything that would show that he, hasn't been doing this. It took him, 6 months to get one clean test. So anyways, I just really am hoping to continue on to get the drug evaluation and to hopefully continue with drug testing maybe. And that's about it.
All right, I ordered some time ago a substance abuse evaluation. I believe last week, Mr. Gilbert indicated he would get that filed along with some other tests. And I do recall, as Mr. Lawrence does, that was going to get filed the next day. It got filed yesterday, but without the substance abuse evaluation and without any input from Ms. Gilbert. I agree with Mr. Lawrence that setting additional hearings at this point is really not going to be productive. I tried to give Mr. Gilbert every opportunity to get the information before me so I can make some changes in where we're at with the visitation. But I don't have all the information I need. So we're going to leave this hearing. I'm not going to set a follow-up hearing when a substance abuse evaluation is done, when Ms. Gilbert has input into that evaluation, when that evaluation is filed with the court, then Mr. Gilbert can note this on for an additional hearing, and I'll consider changing the visitation at that time. Until we get there, I'm going to leave the supervised visits in place that we have right now. I'm not going to strike visitation. I think if Mr. Gilbert can do supervised visits through reconnecting families, then I want that to occur.
So, Your Honor, they've got their email address. How does this stuff usually get filed? I talked to them the other day and I've gave them both of their email address. The counselors down there said they would get the copies of everything.
Well, typically they would give you the report, I believe, and you would bring it to the clerk's office and file it. And if they haven't reached out to Ms. Gilbert, call them and ask them why and make sure that they do. And if you've done the evaluation and all they need to do is talk to Ms. Gilbert, you may be able to get us back here in a couple weeks. But right now, I'm going to put the burden on you to get that filed and then set up another hearing. Okay. All right. Thank you.
Look iPad area.
Yes.
Okay, great. And then do I have Aaron Gilbert?
Yes.
Okay. And then I have Mr. Lawrence on this case. Good morning.
Morning.
All right, let me pull up your digital file. And I did get a draft order on this. What I understand is that this was placed on today's docket by Mr. Gilbert for an adequate cause determination. Respondent let's see. Excuse me, Ms. Gilbert, you are requesting the change in the parenting plan, correct?
Well, so I guess this started, yes. I mean, this all started with a restraining order and then I guess a change in the parenting plan. So John hasn't had visitation until he completed what he has now completed.
Mm-hmm. And I'm just looking back at the prior judicial officers' orders that are in effect. So Mr. Gilbert, fill me in on why you have noted this up on today's docket. It looks like you're asking the court to deny adequate cause to change a parenting plan.
I want the parenting plan to stay exactly the same as it is. I want my visitation rights back. I did the drug evaluation. I did the hair test. I did everything came back negative. The evaluation, there's no recommendations, no nothing. I do not do drugs. I don't do any of that. I just want my visitation rights restored back exactly how they were.
So what I'm having trouble seeing, and I will acknowledge, especially given that your docket starts with the number 18, that you folks have been involved in this case for a very, very long time. You've had other judicial officers in this case. I am stepping in once many, many years have gone by. I'm just, and I'll probably turn to Mr. Lawrence next. I think my concern is exactly what has been filed in front of me today appears to just be Mr. Gilbert asking me to find that there's no adequate cause to change a parenting plan, but I'm not really sure that's in my purview at the moment. So typically what would happen is the person wanting to change the parenting plan would file a motion asking for me to find adequate cause to do so, and then the opposing party would object. And it looks like we might be doing this a little bit in reverse. Mr. Lawrence, help me out here.
Yes, Your Honor. The action that we're currently in court for was the result of Ms. Winkles being supplied with, I believe, a Facebook post by Brenda Gilbert, and that is John's current wife. And she was alleging that John was using drugs, that they got involved in a domestic violence dispute. So this was supplied to Aaron, who became very concerned about what was going on when Max goes to visit. And so Aaron filed for a modification of the parenting plan. And the issue that the court was trying to deal with was to get Mr. Gilbert to undergo a substance abuse evaluation with the input of myself and Ms. Wilbanks. Mr. Gilbert contended that he had done that evaluation, but we had no proof of it. It was not filed with the court, and I had not received a copy of it, and I believe neither had Ms. Wilbanks. So we essentially put it on Mr. Gilbert's shoulders that if and when he completes the evaluation, then we would reschedule this matter and address it then. Mr. Gilbert did file that evaluation. It did indicate that they were not recommending treatment. And so that's pretty much where we're at right now. Ms. Wilbank still has the motion to address, but it appears that the underlying fact pattern may not exist.
I see. And when, thank you for that. And when I go way, way back, I do see back in December of 2022, Ms. Gilbert had filed this adequate cause motion, and it looks like the judicial officer at that time essentially just kind of kept reserving on it pending the outcome of some of these evaluations. Does that sound correct?
Yes.
Okay. And then there was a restraining order put in place at one time. Is that also accurate? Temporary restraining order.
Yes.
Temporary.
Yeah.
If both
And-
parties agree just to go back to the normal visitations, can we just do that? I mean, all the evaluation paperwork, the drug test, the hair test, everything's came back negative.
So I was just, served this or, got it in the mail over the weekend, so I did not have time to respond. I was considering asking for like a continuation just because all of this is done, but I have still heard that things are not going great at his house. They're still fighting. His wife just got a DUI. I mean, things are not going great over there still. So that's where I am.
Yeah.
I wanted to do a possible ask for more just so I could get maybe police records to see if any more action has been happening at their house for the last few months.
And when did you say you received this motion, ma'am?
Just in the mail over the weekend. I mean, I didn't get it until Sunday, but yeah.
Okay. Mr. Gilbert, when did you mail out this motion?
It should have been right after I got it, like on a Wednesday or so.
Okay.
Could have had it for a few days in our mailbox,
You think you mailed it this past Wednesday?
like 2 weeks ago on Wednesday.
Oh, 2 weeks ago on Wednesday. Okay, well, she's telling me she got it this weekend. What I would like to do, I better understand the posture of this lengthy case. I think that we should actually set this for the show cause hearing. This will be both based on Ms. Gilbert's original December 2022 motion, where the judicial officer simply reserved ruling on many months. This will also include, sir, your motion to ask this court not to find adequate cause. I take at face value that Ms. Gilbert says she was just served this weekend. That wouldn't be adequate time to proceed today. What I'd like to present to the two of you is either 1 or 2 week, very short, set over. And at that time, we will do a show cause hearing where the two of you will testify. I'll take into account any written documents that you've submitted, and we will make the final ruling on whether there's adequate cause to move forward with changing the parenting plan or not.
So if we both agree, can we go back to the same old parenting plan?
If you both were in agreement just to strike the adequate cause motion, yes.
Okay.
So what we have outstanding is an adequate cause motion and an adequate cause motion objection. If the two of you were striking that, then yes, we would not be making changes to the parenting plan.
All right.
Okay.
I strike it, but I
How,
would like it too.
say that again?
I would like to strike it down or whatever, but I also want to spend time with my kid this summer too.
Yeah. Would ma'am, would 1 week be enough time to next Wednesday? Would that be enough time for you?
Yeah, I think so. I mean, I have to request the records, and I don't think you get them back right away, but a week I think should be okay.
Okay. So let's go ahead and go to the show cause on the adequate cause motion. And I'm going dating that motion all the way back to December of 2022. And Mr. Lawrence, are you available on next Wednesday at 9 a.m.?
Yes, Your Honor.
Okay. All right. So I'll see you back both just in 1 week, and we will have that show cause hearing. I will make a determination about the adequate cause.
Perfect.
Okay.
Thanks.
Thank you. So what we did at our last hearing was set over the show cause hearing because it sounded like to me that Ms. Gilbert wanted some additional time to respond. And I have received on August 7th some additional filing from you, Ms. Gilbert.
Yes, which I just realized I didn't give to Keith, but yes.
That you didn't, give that information to the guardian ad litem?
Yeah.
Okay. So hold on, I'm just working with okay. So let me just start with Mr. Lawrence. It sounds like there was additional filing from Ms. Gilbert that you may not have in support of the motion to change a parenting plan.
I have not seen those, Your Honor.
Okay.
Sorry.
And it looks like it's, probably relevant information for the guardian ad litem by way of police reports, which my gut instinct tells me are probably a big basis for you bringing this motion. Is that correct to say?
Correct.
Okay. So what I'd like to do, unless Mr. Lawrence wants to move forward anyway, but my preference would be for just to set this out 1 week and have you get that information to Mr. Lawrence so that the court is able to have his input before making a decision on this.
Can I object to that, Your Honor? I can't miss work every week to continue on. I'm going to lose my job. I'm currently paid up on all my child support, everything else. I did everything the court's asked. The drug test, all the samples, everything came back negative.
Go ahead, ma'am.
I mean,
I
sorry.
heard you, Mr. Gilbert. I heard you, Mr. Gilbert. I'll hear from the other parties and then I'll make a decision.
I mean, I did let Keith know that I had found out that that Brenda was arrested and had her daughter, kind of taken out of the home. She just has supervised visitation too. So, and then I guess, so my next step is, wanting to get the information from Lewis County, so I can see what's going on with her case. So yeah, I don't know if you want to just do another week or if we want to wait until I actually have that information, from Lewis County.
So here's what I would say, ma'am. If this is your motion for adequate cause to change a parenting plan, but you have additional information that you plan to file in support of it, the court's inclination would be simply that we would strike today's hearing. You renote this when you're ready for the court to decide a motion on adequate cause.
Oh, okay. So after I have the information, then I would just file it and set a new court
Right.
date.
I would say bring this motion back before the court once you believe the filing is complete and you're ready to go to hearing. It sounds like the last time we met and then today there's additional information you want the court to consider.
Right. Unfortunately, yeah. Last time I didn't realize it was going to open a can of worms. So
Yeah, right. I get it. Mr. Lawrence, I guess I'll turn to you. It sounds to me like that Ms. Gilbert, the moving party, isn't necessarily prepared to move forward on her adequate cause motion today.
That's fine, Your Honor. I did review the records in Odyssey to see what I could find on Brenda Gilbert. I didn't find anything that I thought may have been an issue. And so whatever arrest she may have had isn't resolved yet. And so I think that having Ms. Wilbanks renote it once she has the information she wants us to look at would be the best course of action.
In the meantime, I did want to say, John does supervised visitation, and Max, our son, is in sports and has asked if his dad can come to his games. So I don't know if that's a possibility in the meantime, if it's, obviously I'm going to be there. So is it okay that John comes to his stuff down here? Or?
If you, ma'am, as the moving party and the one with the concerns in this case, are open to allowing him to be in person at the games, the court has no issue with that whatsoever.
Okay, thank you.
Mr. Gilbert, what I think that we'll do then is, I'm not setting a new date. Ms. Do you still go by Gilbert, ma'am?
Yeah.
Okay. I just want to make sure I was using the right name. I know sometimes these cases start with the married name and then change. So Ms. Gilbert, what I would ask, because there is a bench order in place that does put some restrictions on visitation, I would ask, I'm not going to set a date, but please get this back in front of the court in a timely manner so that we can fully address for Mr. Gilbert what that looks like going forward. Okay.
Yes, definitely. Thank you.
But Mr. Gilbert, the court has no issue with you attending sporting events per Ms. Gilbert's request.
Okay, I'm asking the court. I was ordered to do the hair follicle test, this, that, everything else and stuff. It all comes back. I said I don't do drugs. Everything's came back negative. I got no evaluations. What does the court want me to do so I get my week on, week off before summer's over? She will never be happy. She's not going to let me give visitations. I need to address the court. What am I failing at? I paid all my child support. Every drug test came back.
So Ms. Gilbert, let me ask you this. The reason the court changed visitation was because you filed a motion for adequate cause wanting to change the parenting plan. Are you still asking for supervised visitation versus going back to the original parenting plan?
Yes. This whole thing.
Hold on, Mr. Gilbert.
Sorry. This whole thing was not just about drugs. It was the complete chaos that is happening at their house, and it has seemed to continue. And so that's my concern. And just this morning, Mr. Gilbert texted me and said, I'm probably right that Max probably shouldn't be there right now while he's going through this. So yeah, I just, until I know that him and Brenda are done officially, I just feel like it's not a good environment for Max.
Okay, well then, ma'am, I am going to change my ruling somewhat, because here's what's happening. You have filed a motion to change a parenting plan. The court has put some additional restrictions in place without actually making a determination on that. But you're now saying you want to present more information and you're not ready to move forward on it. But I think Mr. Gilbert has an excellent point, which is, in the meantime, while you're wanting to document the file with more information that we don't have, he's losing out on time with his child.
I do have the information that, his wife was just recently arrested because they got in a huge fight and he called the cops on her. That was just a month ago. So nothing has calmed down.
Okay, then what I want you to do, here's going to be my ruling. Mr. Gilbert, it is going to require you all to come back to court next Wednesday. I'm going to, rather than keeping this out, I think you make an excellent point, sir, that the court has put additional restrictions on you for a lengthy amount of time without this matter moving forward. I do think we need to have resolution to that issue. So I think that I know, I understand what you're saying about missing work, but I do think you all should come back next Wednesday at 9 a.m. Ma'am, please get that information that you filed with the court to Mr. Lawrence. And I do want to make a ruling on your request to formally change the parenting plan, okay?
Okay.
So we'll be able to make a ruling next week and find out something? I mean,
Sir, what it'll initially be is a ruling on whether there's adequate cause to change the parenting plan. If I find adequate cause, I can put a temporary plan into place and then set you all for trial on the permanent parenting plan. Or the court can find there isn't adequate cause to change the parenting plan.
okay, I guess summer's gonna be over. All right, thanks.
Yeah.
He
Okay.
is the one that took 6 months to get a clean drug test.
And there's no question in front of you. Please
Yes.
get that information to Mr. Lawrence. Mr. Lawrence, are you available next Wednesday on the 16th?
Yes, Your Honor.
Okay, I appreciate it. We'll see all the parties back on that date.
Thank you.
Do I have both of you present?
Yes.
Yes,
Okay, great. That's you and iPad 1. Thank you. And I do have Mr. Lawrence on here. Give me a second just to pull up your digital file. Okay. So when we were together last on August 9th, I think one of the concerns the court raised was we have this adequate cause motion that's been hanging out there. There's been ruling reserved on it. But in the meantime, a judicial officer had changed, at least temporarily, visitation pending some additional information coming in. I've reviewed the evaluations or not evaluations, but the UA reports that have come in. I think that was one of the things the prior commissioner was wanting. I've looked at the documents from the original show cause motion. I haven't, Ms. Gilbert, received any additional information. I think when we were together last, you were maybe going to supply some additional information to support your request for adequate cause finding.
Yes.
I haven't seen that. So first, I'm going to turn it over to you, then Mr. Gilbert, and then I'm going to get input from Mr. Lawrence. So
Okay.
go ahead, ma'am. Where are you at with evidence and your request to change the parenting plan?
I did file paperwork on Friday. So I received, a notification that John's wife had her daughter, taken away or lost custody. And so I got that information and filed it with a declaration on Friday. Just with some other stuff, a text from John saying that he agreed that his house is not a good place for Max. And a declaration from his stepson about John's behavior.
Okay, so I'll tell you, unless you provided a bench copy, which is a second copy for the clerk to give to me, there's absolutely no way I would receive your documents if you dropped them off Friday. So they're not in our digital system either. We have nothing scanned in since August.
I don't know what that means. I have to request specially for it to go to you?
No, it just means you can't drop things off 3 days before a hearing. It's not going to get scanned in administratively, and it's not going to make its way to me unless you deliver a second paper copy that's called a bench copy. So I have nothing that you're discussing in front of me. Okay.
I thought that it just had to be filed by Friday. I must have misunderstood. I mean, last time I filed it on Monday before court and you had it then. So I just must have misunderstood, but I did file something, so I'm not sure.
Okay. Let me chat with Mr. Gilbert. Mr. Gilbert, have you received the documents that she's referring to?
I got an email from her. Yeah.
Okay. What's your position on this? She's seeming to allude that you are in agreement that your house is not a suitable place for the child right now.
It is now. I'm the only one staying at the house.
Say that again. I didn't catch it.
I'm the only one staying in the house, so it's a safe spot for the kid.
Okay. You're talking about, so Brenda is out of the house?
He's not staying in the house right now. No.
Okay. Well, I don't have anything in front of me.
I did give it to Keith, the guardian.
Okay, I'm gonna talk to Mr. Lawrence shortly. Anything else, Mr. Gilbert, you want me to know? Are you objecting to a change in the parenting plan at this point?
Yes, I object to it. I want it to stay exactly the same.
And as I see, you haven't had visitation now for quite some time because of these temporary orders. Is that right?
A very long time.
Okay. And I did receive your negative and review your negative UA results. So let me turn it over to Mr. Lawrence and get some input. It sounds like, Mr. Lawrence, you may be privy to documents I haven't seen, so I'll ask for a little input from you.
Yes, Your Honor, I did receive an email from Aaron last week. And as she indicated, there was several documents in there. There was a statement by Brenda's current husband, or past husband, rather. There was a statement from Aaron and John's older son. And from what I gleaned out of the number of documents that she sent, is that there's complete chaos going on between Brenda and John in their home. And I would not recommend that the court allow visitation if the two of them are residing in the same home. John has undergone his drug and alcohol evaluation, but if the two were together, I would recommend that the court consider John undergoing a psychological evaluation with a parental risk component. If those two can't separate somehow, this is no environment for Max.
Mr. Gilbert, do you want to respond to that?
Yes, like I said, we're not living together. I was a father before I was a husband. I'm a dad. And I lost my parenting rights over a bunch of stuff that I proved. I don't do drugs. I don't do any of that stuff. So yes, we are not living together.
Looking to see, and I don't have confirmation of that, sir. I can certainly take your word here right now, but I don't have a declaration to that effect from any individual. I'm looking to see if we have an order on the adequate cause. Ms. Gilbert, have you filed a proposed order on the adequate cause decision?
The proposed parenting plan?
No, it's called an order on adequate cause.
Oh, I do not believe so.
Okay.
I do have something to say about him and Brenda being together if I have the opportunity sometime.
Go ahead.
Oh, just that he has, I mean, this has happened multiple times where he says that him and Brenda are no longer together. And then they are together, unfortunately. And I do believe that this is just a lie, unfortunately, to get Max back. Anyways, yeah, I just do not believe that even if Brenda is not living there, which I do not believe that she's not, but if she isn't, I believe that would just be temporary. They very much have a history of breaking up and getting back together. So until things are final, I would not like Max to go there.
So here's what I'm going to do. I think this motion for adequate cause has been hanging out there way too long, and the court needs to make a ruling. Based on all of the evidence in the file, including input from Mr. Lawrence, I do believe the first ruling I'm making today is that there is adequate cause to change a parenting plan. This doesn't mean that I'm adopting any specific parenting plan right now. What it means is I believe there's enough evidence to move this forward to a trial, but maybe mediation first on what the new parenting plan should look like. So after today's docket, I'm going to fill out what's called an order on adequate cause to change a parenting plan. I will find that Ms. Gilbert, who was initially the respondent in the underlying action, did make a motion for adequate cause decision, that today we did hold the adequate cause hearing, that I have jurisdiction over this case, and that I am finding that there is adequate cause to hold a full hearing or trial on the petition. The trial date will be set at a later date when we have further, when we're ready to get to that point. The other findings I'm going to put in this order are that for now, the prior judicial officer's temporary orders suspending visitation remain. Mr. Lawrence, what were the evaluations you were recommending? I wrote down parental risk assessment or component.
Right, yeah, a psychological evaluation with the parental risk component.
Okay, I am going to add that, Mr. Gilbert, to the order as an affirmative obligation that you will need to do. What I'm going to do after that is, and Mr. Lawrence, do you still have time with us on this case to remain as GAL?
I'm available to remain, however, my funds have run out.
I would like to keep you appointed to this now that I am finding adequate cause and moving this on to a hearing, trial, or mediation on changing the parenting plan. I will approve a request for additional time and money on this.
Okay.
Do you have a template order you could send over to me ex parte on that, or do you need the court to do it?
I don't have a template, Your Honor. I'm sorry.
Okay, let me just make a note for myself. And I'll get that done after docket as well when I do the adequate cause motion.
Your Honor, can I please at least just get the weekends with my kid?
Not right now, sir. I do want, what I'm going to do is set a review date. And we're going to set it 30 days out. And I would like you in that time, as best you can, certainly understanding it is difficult to get into medical providers. I would like you to get the psychological assessment with the parental risk assessment. I am also hopeful that by me approving some additional time and hours from the GAL, that we can kind of get to the bottom of what your living arrangement with Brenda is. I'm not convinced standing here right now that more likely than not, the two of you are permanently not residing together. So I am going to need some further input on that. So my hope is when we come back in 30 days, it'll be both a review hearing on kind of the immediate visitation issue and your compliance with the psychological evaluation. But then I would also like to address at that hearing whether you're ready to go on to the full hearing or trial on permanently changing the parent plan or not. Okay.
Okay.
So that's going to be, I'm looking at September 13 or 20. Mr. Lawrence, do you have a preference?
Your Honor, the parental risk assessment can take several months. So,
Oh, okay.
so the 20th would be preferable. I can address the living situation, and I can address whether or not Mr. Gilbert is attempting to set up an appointment, or he may even have an appointment, but it may be down the road.
Let's do that. I think that's a great idea. And thank you for that additional clarification. So let's set this to September 20th at 9 a.m. back on this docket for a review, for essentially a status review on those two issues. And then we will also talk about, I know Mr. Gilbert, you want to move this forward. We can talk about whether we're ready to get you guys sent on to, mediation or a trial. Okay.
Okay.
Any questions for me on this matter? Otherwise, I will get the adequate cause finding signed and filed. I'll get the additional time and money approved for the GAL, and then we'll see you back on September 20th.
Yeah, since Keith brought it up or what, so where's the best spot to get these evaluations?
Your Honor, the only person that I know of locally that does that is Dr. Stephen Maharg at Northwest Psychological in Longview.
Do you have any idea what that costs?
It runs around $1,500. The last I heard, I don't know what his current rates are, but I can provide John with Dr. Maharg's contact information and so he can get started.
Okay. Thank you. I appreciate that. All right, Ms. Gilbert, Mr. Gilbert, you are free to log off.
Thank you.
I believe, Mr. Gilbert, you're in one of the iPad booths.
Yes, I am.
Okay, and do we have Aaron Gilbert with us?
Yep, I'm on here.
Okay. So this is 18-300-23808. I believe Mr. Lawrence, oh, there you are. Good morning. Sorry, I have 2 pages of Zoom screen, so I'm not seeing everyone right away.
Yeah.
Okay, so we did, last time we were together, we talked about, I had issued an order granting or finding adequate cause. I think that we also had issued an order needing more investigation from the GAL before we moved forward with a new parenting plan or trial on the new parenting plan. So I guess first, maybe Mr. Lawrence, I'll check in with you and see where we're at.
Well, Your Honor, as you are aware, there was an allegation and a police investigation earlier this summer whereby John and his current wife, Brenda, got into a heated argument, and she alleged that John had assaulted her. He was not charged with that. And there were a lot of issues, and Brenda suffers from some mental health issues. And the question was whether or not it was safe for Max to be there while the two of them were fighting. And John had indicated that Brenda was no longer living at the residence. And so on September the 12th, I made an unannounced home visit, and Mr. Gilbert met me out in the front yard and indicated that Brenda was indeed living there with him now, and that she is undergoing mental health counseling and I believe drug and alcohol counseling as well. The court had ordered Mr. Gilbert to get a psychological evaluation with a parental risk component, and I provided him with the contact information for Dr. Stephen Maharg at Northwest Psychological, and that's pretty much where we're at this point, because I haven't heard whether Mr. Gilbert has an appointment for that evaluation.
Okay. Thank you, Mr. Lawrence. I appreciate that. Mr. Gilbert, what can you tell me about the court-appointed psychological evaluation?
They're months out, and right now we just got out of fire season. Money's tight. We've been shut down, and I know looking outside, you wouldn't believe it, but we've been on a level 2 all summer long, level 3, and shut down. So with that, I would like to know what evaluation could be next. Like you said, this cases are going on forever. I was court ordered to do the hair test and a drug evaluation, clear back in like January. I don't do drugs. I never have. Everything came back negative. The hair sample, the evaluation, nothing needed, everything else. And now all of a sudden, this evaluation. So after this evaluation, what is next?
So that I'm not addressing that, what's in front of me today. is whether you have complied with my August 16th ruling that you obtain a psychological evaluation with parental risk assessment. So are you letting me know that for whatever reason, and I certainly understand there are reasons, are you telling me that that has not been scheduled yet?
It has not been scheduled due to financial difficulties.
Okay. When do you think you'll be able to get that scheduled?
I don't know, how long does the supervised visitations? I get those and that's another $400 a month. It costs me $100 for 2 hours to see my kid. When does that end?
So, sir, you're answering a lot of my questions with questions of your own. That is that's not my role in these proceedings. My role is to ask you the questions. So the question I'm asking you is, when do you think you will be able to get the psychological evaluation scheduled?
As soon as we get back to work and stuff, I will try.
Okay, so can you estimate the length of time that may take? And I'm asking so that I can get you back in court as quickly as possible once you do have that done.
I guess a few weeks.
Okay, let me turn to Ms. Gilbert. So Ms. Gilbert, at this time, the only thing I can do obviously is keep our bench orders regarding suspension of in-person visitation in effect. So I'm not going to be making any changes. Everything's going to remain status quo. So Mr. Gilbert can get that done. What would be your request for timing to come back to court, or do you have a preference?
I don't have a preference. I mean, I don't understand why he can't schedule it if they're months out and then, or, get it on scheduled now.
Yeah.
If it's months out, he doesn't need the money now to schedule it. So.
Okay. So what I'm going to do
Can I
is,
please ask something, Your Honor?
Mr. Gilbert, go ahead. I didn't catch your statement.
Can I please ask? So with the hair follicle test that was ordered, that evaluation that was ordered, those come back negative. If I do this evaluation and it comes back, I have no issues, what can be ordered next?
Mr. Gilbert, what I'm telling you is, I don't have a crystal ball. I don't know what that evaluation is going to show us. It's been recommended because there are enough allegations that your child may have witnessed violence in your home. So our overriding goal is always what is in the best interest of your child. To that end, we've asked for this evaluation. Once I've had a chance to review that and the GAL has had a chance to review that, we will come back and talk about it and where we go from there. But that really is the next step. So what I'm going to do, sir, is I'm going to set this for review of compliance with that evaluation 4 weeks. I don't think it's going to happen before then. I'm pessimistic it will happen by then, but I don't want you all to be in limbo. So I'm going to set this to Wednesday, October 25th at 9 a.m. back on this family law A docket. Does that work for the parties?
Yes, for me.
Okay. Mr. Lawrence?
Yes, it works for me, Your Honor.
Okay. And Mr. Gilbert?
Yes, it works for me. But when I talked to the GL, he said Max didn't witness anything at the house. So he never did see no violence. There was nothing there. Parenting plan proves that. On the dates that the police reports were done, the parenting plan proves that I didn't have Max. I didn't take Max to my house when I had him.
Okay. All right, Mr. Gilbert, what I am talking about right now is you getting the psychological evaluation before we can move forward. Hopefully you can get that done, or at least a scheduled date by October 25th. And we'll see you all back October 25th at 9 a.m. Okay.
Thank you.
All right. Thank you all. Do I have John Gilbert and Aaron Gilbert present? And I believe Mr. Lawrence is on this matter. 18-300-23808.
I'm here, Your Honor.
Yes.
Great. I see everyone present. I have this on for a review of compliance with the evaluation. Mr. Gilbert, I don't see anything in my file, so let me start with Mr. Lawrence and then I'll come to the parties.
Your Honor, I checked with Odyssey yesterday and I again found nothing there. I have received nothing through email for Mr. Gilbert. And so my assumption is that he has not complied yet.
I have a date set,
Oh, great. What is that date?
November 28th. It's a Tuesday.
Okay.
I
And
didn't know I was supposed to apply with everything else. It's with the Dr. Stevens or whatever for the psychiatric evaluation.
yep, the psychological evaluation. Okay. You said that's November 28th.
Yep,
Okay,
it's a Tuesday.
great. So
Can
it'll,
I ask?
oh, just a second, sir. Hold on. I'll come to you with any further input or questions. Let me just do the basics we need to get done. If that's going to be on November 28th, it will likely take some time to get the report to the parties and have a chance to review it. So I would recommend we come back. I know this is during the holidays, so I don't know people's availability. We could do December 20th or 27th, or we could bump it into January. Mr. Lawrence, what's your schedule like?
My schedule is free, Your Honor. However, my experience in working with Dr. Mahard is that his initial appointment is going to be like a clinical interview. There may be a separate date for him to do testing. And then there's going to be collateral interviews with Dr. Mahard. And so my suggestion is we wait into January in order to get all this stuff together.
Okay. Mr. Gilbert, did you want to say something?
Yes, is there any way I could see my kid unsupervised? I mean, I do not understand this. I've got nothing in my past, nothing in my history, nothing at all that says I can't be around my own son. I mean, the stress this has caused and everything. I'm not working right now. This has caused ungodly stress on my life, my work, everything. I mean, at first I was not telling anybody about this because being branded an unfit father that can't be around his kid, but it's just gotten to the point it's unbearable.
Okay. I will comment on that after I hear from Ms. Gilbert. Go ahead, Ms. Gilbert. What's your input on, I guess what Mr. Gilbert just said, but more importantly, if our follow-up court date in January works for you? I'm looking at probably January 17.
Yes, January totally works for me. I do want to say, I just want to make sure that he is getting the right test, like the drug test. He did not do the right thing. So I just don't want to come back in January and find out that he did not do the correct evaluation. So anyways, but yeah, as far as unsupervised visitation, I'm still a hard no if possible. He has done nothing to comply with the court, basically.
Yeah. Here's going to be my ruling. I am going to set our review date on the psychological evaluation completion and report to January 17, 2024 at 9 a.m. I, at this time, am declining to revisit or revise visitation. I think what the court has put into place is appropriate under the circumstances and facts in front of me. I disagree, Mr. Gilbert, that there's nothing in the file to support the type of visitation we have put into place. So I am leaving it as is until we get the results of the psychological evaluation. And further input, I think you'll remember from my August bench order that I did also have concerns about the living environment with which the child had been exposed to in your home. So I'm going to leave visitation as is through January 17th review date. Anything else the parties need from me?
I would like to know why the court's recommending this.
So I've already made my record in all of my bench orders. We've talked about this numerous times. Every time you've been on, it's been like pulling teeth to get you to do the evaluations the court has asked of you. So I'm simply, I've issued my ruling. Visitation stands as is through January 17th, our next review date. I'm very glad to hear that you have the evaluation set up for November 28th. And I wish you the best of luck through that process, and we'll talk again January 17th.
Thank you,
Right.
Your Honor.
Thank you.
Thank you.
all. You're free to log out.
I'm not hearing from John Gilbert, so let me just specify, Mr. Gilbert, if you are on the Zoom call today, if you please press the icon, the microphone icon to unmute, and then also if you're calling in using a phone number, dial *6. That will alternatively mute and unmute you. Again, John Gilbert, are you here today? All right, there's no response. My understanding of why we're present here today is related to the status, getting an update on the psychological evaluation and parental risk assessment. And from my review of the file, I did not see that. So we'll hear from Mr. Lawrence for an update.
Your Honor, I've had no contact with Mr. Gilbert recently. He is very much aware that I had requested this and the court had ordered it. And I gave him information as to who to contact, and I've heard nothing since. As the court may recall, this matter was on for last week, but due to the ice and snow, it was kicked over. I tried to reach him to let him know that the court was going to start an hour later, and he didn't show up for the hearing. And so I'm not sure if he was aware that today's hearing was to take place.
Okay. And so, and he is the subject of the psychological evaluation with the parental risk assessment, is that correct?
Yes.
And if that having that not be, or having it be incomplete, do you have any recommendations? Because last time I understand that the visitation was status quo. There was no change in the visitation for father.
That's correct, Your Honor, and I would again ask the court to continue with the status quo.
Okay, all right, thank you. Okay, Ms. Gilbert, happy to hear from you.
Yeah, I honestly haven't heard from John, so I'm not sure if he has done any of this or knew about court or anything. So, but yeah, I do just have a question on the supervised visitations. So now we're just doing Saturdays, but he's requesting 2 days a week, which I do understand that he wants more time. I mean, I guess he's not here to even do that, but I don't want to have to drive down there 2 days a week. It's a lot of gas. So I was just going to bring that up, but John's not here to discuss it, I guess, anyway. So.
Yeah, so I'm looking for a particular order that specifies the parenting time. Can any of the parties point me to a kind of a date and time when that order may have been entered? There's been a variety of them entered. I have, well, here's one from May 8th of 2023. It says, Mr. Gilbert may have supervised visits with the son once per week for 4 to 6 hours of reconnecting families. He's responsible for the costs, and he's to cooperate in bringing, Ms. Gilbert is responsible to cooperate in bringing the son to the visits. So that's the order that exists. So there's been no change to that, unless the parties can point me to something different.
Nope, I think that is where it is. So.
Okay, let me ask the parties if the psychological evaluation is important. It sounds like the visitation occurs at a professionally supervised facility. Does there need to be added pressure to Mr. Gilbert to comply and get the evaluation done, or does there still just let it ride and then the child is at least safe during supervised visitation? Mr. Lawrence?
Well, Your Honor, Mr. Gilbert has been very resistive throughout this whole process. We had asked for a drug and alcohol evaluation. He fought that for a long time and finally complied. But the issues in the home is the stability in the potential use of drugs still in the home. And so that's why I was requesting the psychological evaluation with the parental risk component. And I would think that he should have at least started the process and tried to communicate with us as to what his intentions are. And I'm not hearing anything. And so my concern is that he just wants to continue on as we're doing ad nauseum. I would recommend that the court invoke some type of pressure to get him to comply with the order.
Thank you. Ms. Gilbert, if the court were to suspend visitation of Mr. Gilbert and the child until he completes the evaluation, does that do more harm or good to the child?
Probably more harm. Yeah, unfortunately. He does like the, weekly visits, so.
Okay. Yeah, there needs to be some movement on that, on the psychological evaluation of the parental risk assessment. And at the same time, I need to be sensitive to the well-being of the child. And if the child is having visits that are positive and safe because they're professionally supervised, it's hard for me to apply pressure such that I would remove any visitation. And I don't really know much more any other tool that's going to get Mr. Gilbert to do what we've asked him. I mean, he may be eternally in the supervised visitation mode on every other Saturday or once a week on Saturdays. So at this point, I'm going to hold off and we'll just. I'm not sure if an additional hearing is warranted at this point. It'd be status quo if he wants to continue, if he is using drugs, or if there's still concerns about his psychological well-being. That can be mitigated and somewhat controlled in the professional supervised setting. And if he wants to make changes to that, he could bring a motion to the court, or if Ms. Gilbert feels that there needs to be a change, then she could bring a motion to the court. If Mr. Lawrence feels there needs to be a change, then he could notify the court of a need for some type of adjustment. So I guess that's a long way to say that I'm not going to do anything today. I think we're going to move forward with the status quo. If there's new issues that arise that are of concern to the parties, the best interest of the child is impacted in some way. Certainly the parties are free to bring that before the court. Otherwise, we'll continue with the visitations that are supervised.
Keith Lawrence, guardian ad litem.
It looks like we have Mr. Gilbert in the courtroom. Give me a minute. For some reason, the case isn't coming. So, Mr. Gilbert, this is your motion. Anything you want to say?
I'm just asking, since I've completed everything that's been asked for and stuff, to reinstate the parenting plan.
Mr. Lawrence?
Your Honor, this has been a long-term process. Mr. Gilbert had been ordered to undergo a psychological evaluation with a parental risk component. He called me a couple of weeks ago and wanted to provide me with a copy of the document. I told him that I could pick it up through Odyssey, and I checked as recently as yesterday, and I don't see it listed in Odyssey. Mr. Gilbert did provide me with a copy. He hand delivered it to me yesterday, and I've had a chance to review it, but I don't know if the court has had a chance to see anything.
No, I have not. So, Mr. Gilbert, I can't make a decision based on information that I don't have, obviously.
I know, I delivered it to the courthouse before I got the court date, so I guess resubmit everything up, start over.
Yeah, according to what we've got here, it was never given to the clerk's office.
It was, okay, I mean, I'm not gonna argue with you.
All
Can
right.
we get a court date set soon, so?
I'm sorry?
Can we get a date set soon? Because like I said, I delivered it all when I asked for this court date. They did a sealed document and everything else there.
Okay, so are you saying that you submitted it to the clerk's office already?
Yeah, I submitted
When?
this stuff before I even got the court date. It was submitted like a month ago.
Not according to what's here. I've got your motion.
Because I don't remember the exact date when I gave Erin, but I submitted it here at the courthouse before I gave it to her. Then I contacted Keith, so
Okay.
It was submitted. I don't know what happened to it, but I can resubmit it. Can we get
Yeah,
it?
you're gonna have to. So file that paperwork, get a new, do we have, Aaron Gilbert?
Yes,
Okay,
I did get a copy of it, honestly, and it is stamped by the clerk, so I'm not sure what happened, but
okay.
Your Honor, if I might interject, I would request that Mr. Gilbert double check the cause number. It may have gotten filed in a different cause number.
Okay. Well, we'll put this on July 3rd, then at 9 o'clock. Mr. Gilbert, get that filed with the clerk immediately. Understood?
Okay, yeah, just right now.
Okay, so we should have John Gilbert. Is that you, Mr. Gilbert?
Yeah.
Okay, welcome to you. And Miss Erin Gilbert, you're here and you can hear me all right?
yes.
Very good. And Mr. Keith Lawrence is present. Let's see, just a quick double check for today's hearing. This is Mr. Gilbert. This is your motion for visitation.
Yes.
Okay. I've read everything that's been submitted by the parties. This is related to the child max. And I reviewed, it looks like we had Dr. Maherg submitted a psychological evaluation of the parental risk assessment that was done on April 29th. And then there's also a report from the visitation specialist submitted on June 29th, indicating that the visits are going well. He's always early, he's always prepared, and it's positive interactions. And Dr. Maherg's assessment was no diagnosis or diagnoses, no major challenges to Mr. Gilbert's parental capacity, and no specific reason to restrict normalized visitation with his son. So that's kind of where we're at with the information that I've reviewed. And then the request by Mr. Gilbert is for to reinstate basically the June 2021 parenting plan with him exercising visitation or residential time on Friday 5:30 till Sunday at 7 p.m. and then summer with alternating weeks. That's kind of where we're at. So we'll first hear from Mr. Gilbert related to your motion, and then we'll hear from Ms. Gilbert and then Mr. Lawrence. Mr. Gilbert.
Yeah, I did everything the courts asked me to do. I proved everything that was put out on Facebook was wrong, so I'd like to just get my visits back and quit dragging this out.
Okay, thanks. Ms. Gilbert?
I mean, the only request I would have, well, I guess a couple, is that Max cannot be around Brenda. I mean, I believe that John and Brenda are separated, so I don't think that's an issue, but I just want to make sure that, or I would like to have an order if possible that Max cannot be around Brenda if he's with John. And also John, you know, because I think they're separated, John is staying at a friend's. And so I'm not sure about Max going there every other week in the summer. I just feel like if John's working, he would, and they're staying at a friend's house. I don't know. I just would feel more comfortable. It was if it was on the weekends when John was there full time.
Okay.
Until John has his own place or whatever.
Okay, so what you're saying is that you, as far as the alternating weekends, you're fine with that, but as far as alternating weeks, that's what your concern is there.
Yeah.
Okay, all right, Mr. Lawrence.
Your Honor, I had a chance to review Dr. Maharg's report as well as the summary submitted by Beth Fellows. John is correct. He's done everything that we've asked him to do. It appears that there are no impediments for him to see Max, and Max enjoys the visits with his father. Like Ms. Wilbanks, I also share a concern about contact with Brenda. She has been one of the primary issues throughout the involvement that I've had in this matter over the last 3 years. And I would hope that Mr. Gilbert is going to keep the two separated. As far as where he's living, Mr. Gilbert had not shared that with me, so I don't know anything about the people that he's staying with at this point.
Okay, thanks. Mr. Gilbert.
I've got An attorney, well, a couple of attorneys working on that. I'm hoping to be back in my house by the end of the month.
Okay, where are you at currently?
What's that?
Where are you at currently?
Pretty much homeless right now, staying in my truck or crashing here and there.
Okay. And then, so if the visitations were to go back to the alternating weekends, tell me where Max would be
Well, I'd go
staying.
stay up at my brother's house or something on the weekends. I have him.
Okay, and where
Or
does
go
your,
to the beach or go do something
where does your brother live?
up in Toodle.
Okay, so that's where you and he would spend the time.
Yeah, on the weekends or
Okay. And, okay. And then, Ms. Gilbert, do you have any thoughts on that?
I mean, it doesn't make me feel great not knowing where he's going to be every weekend, but I don't know if I have any control over that. So
Okay, thank you. Mr. Lawrence, any thoughts on that?
I think as long as Mr. Gilbert is in attendance, I don't see an issue. He's not, other than having Max exposed to Brenda, he's not taking Max and put him in harm's way outside of the home ever, to my knowledge.
All right, thank you. Let me take just a moment to prepare an order. And then, Mr. Gilbert, as far as there is a request related to your Brenda having Max having no contact with her, do you have any concerns with that request? Okay. I'm just going to take a moment to just do a handwritten order, and then I'll let the parties know what the decision is. And if you have any questions, you can ask.
so when could the weekend start?
So like I said, I'll write my decision out and then I'll tell you what the decision is, and then we can follow up with any further questions. One quick question to the parties, as far as an exchange location, where would the proposed exchange location be for the pickup and drop off?
Castle Rock Park and Ride where it's been.
Okay, Ms. Gilbert?
I mean, I live in Portland now. I would love if it could be, a middle area like Woodland or something. But
So you said you're in Portland,
yeah,
and then your
That's
brother?
where the meeting spot's always been on the parenting plan. Even when she moved to Portland, since she was the one to move them away, they still made her bring them to Castle Rock Park and Ride.
Okay. And you said your brother's in Tootle?
Yep.
Thank you. Okay, so I appreciate the feedback that we received from the visitation specialist and Dr. Maherg and Mr. Gilbert going through those different procedures or evaluations and the like. And so I'm going to grant the request for visitation that'll start this weekend. It'll be on the first, third, and fifth weekends of each month as defined by Friday. So it'll be from Friday at 5:30 to Sunday at 7 p.m. Given the change of the parties as far as where you're living and where the exchange, or pardon me, where the visitation is going to occur, I think that the exchange location should be at the Woodland Safeway. So that's where the exchange will occur. Parties will meet there and do the exchange. So at this point, I'll grant that motion. Oh, and I'll also just add that there will be no contact with what's Brenda's last name?
Gilbert.
Gilbert. Okay. Let me just write that in here.
I do have one thing, Your Honor, if possible.
Yeah, go ahead.
Max's birthday is next week, and so I have a birthday planned for him this weekend. Is it at all possible to start next weekend?
Mr. Gilbert?
I've already had him miss 2 of his birthdays over this crap.
I mean, I have like his friends coming, etc. I didn't,
I had my
like
kid too
Saturday.
every other week already too.
So just a quick ground rule. When one of my ground rules in the court is just when one party's speaking, nobody interrupts. So go ahead and finish, Ms. Gilbert, and then we'll hear from Mr. Gilbert.
Yeah, I mean, I have the whole party set up. So, I mean, even if it was, Saturday evening or something, I could, if John wanted him for, Saturday night through Sunday or something, I could do that. But I just have the party set up for Saturday day.
Okay. So, this motion's been pending for a little bit. The parties didn't know how the court was going to rule on the particular issue, or how the court, what the details would be. So I think the fact that a party's already been planned, the party should go ahead as planned. So then the visitation will commence on the third weekend, which will be on the 20th. And if Mr. Gilbert would like to have that weekend visit that he's missing out on this week, then we could just make that happen next week. So for this month, it would be the second, third, and fifth weekends of the month. So that's when the exchange, or that's when the visitation will occur. I have a copy for each of the parties. Any questions on your end, Mr. Gilbert?
No.
Okay, Ms. Gilbert, any questions on your end?
No, Your Honor.